Obviously, you'll have a proper understanding of constitutional law. You have gone through the cases, most importantly of fundamental rights. So as an administrator, you're expected to protect those fundamental rights.
Why you chose civil service over judiciary?
We have freedom of choice.
India has 15 judges per million, according to India Justice Report.
We can have an NJC, which will ultimately streamline the appointment.
Sir, district courts का तो problem फिर भी solve नहीं होगा इससे?
Let's say there are women in the judicial setup or the judicial in the courts. So obviously the infrastructure would cater to their demands. All these gives a lot of confidence even to parents that yes, their daughter can pursue legal profession.
The Trump's tariff policy were in controversy that he is imposing such tariff policy. So sir, was he violating the international trade law?
Honestly, they are not looking for what articles you quote or what provisions you give or what case laws you give as part of your answer. They are looking how you answer.
Sir, the last message you would like to give to the law students as well as all the aspirants who are appearing for the interview. Hello and welcome to Forum IAS podcast. I am Shivani Jha, and the purpose of today's podcast is to help those students who are appearing for interview, and especially the ones who have law as their optional. And for this, we are joined by our faculty, Naveed sir. So, welcome to the show, sir.
Thank you very much.
Okay, sir. So, sir, my first question is that how the knowledge of law help an administrator on ground? That what are the plus points there?
See, when you study law in your graduation, or if you have taken law as your optional subject, you become aware of different laws, obviously, which are part of the syllabus, mainly constitutional law, administrative law, and international law under paper 1, criminal law, law of contract, law of torts, and other contemporary legal developments, and various other laws as well. So the moment I talk about these different laws, obviously, the board, while going through your DAF, when they say that you have either done your graduation in law or you have taken law as an option subject, so based on your DAF, obviously they will have a certain expectation from you that, okay, you will have certain knowledge. For example, they can ask you, what is the meaning of this word law? Has law been defined anywhere in the constitution itself? So you have to give a very, balanced and a very clear answer. If you do not know the provision, simply say, sir, I am not aware. And the correct provision is Article 13(3)(a) or 13 Clause 3 subclause A, where the word law has been defined. Now, the word law includes not only legislations made by Parliament or state legislature, but also ordinance, regulations, bylaws, etc. So it also means it also covers subordinate legislation. Now, as an administrator, so you're asking that how it will be beneficial, right? Obviously, you'll have a proper understanding of constitutional law. You have gone through the cases, most importantly of fundamental rights. So as an administrator, you're expected to protect those fundamental rights, empower citizens through RTI, right? Let's say if they are seeking information, and on top of everything, you're supposed to follow the principles of natural justice. Because as an administrator, it is also your duty to ensure that any citizen is not, they're not subject to any, or they're not made to run from pillar to post, let's say, for example, to seek information. And hence, incorporation of natural justice, which includes two elements. Audi alteram partem means that no side should be condemned unheard. So it means while taking decisions, administrative decisions, at times it's possible that you will be, you'll be made to take decisions in a quasi-judicial manner or in an adjudicatory authority. Or in other words, the other aspect of natural justice is that you should not be biased. So when you study all these basic principles as part of, let's say, constitutional law or administrative law, then obviously you imbibe them while implementing them. And you are, more than that, you are aware about these laws. For example, if you are a sub-divisional magistrate or a district magistrate, then you know about the various criminal laws. Obviously, at first hand, considering the fact that you have studied them either in your college or while preparation. So in that sense, definitely it helps you, right?
So, sir, what could be the answer if the board asks that why you chose civil service over judiciary? So what could be the wise answer, and why people generally don't go for judiciary? And
no, it's not that people do go for judiciary. See, these are ultimately based on one's choice, right? If someone is so passionate enough, or he or she really wants to appear for civil services, we have freedom of choice, right? Under the Constitution of India, they have their freedom to live with dignity as well as their choice. They have freedom to make their decisions. So this is one constitutionally guaranteed right to them. Ultimately, it's their choice. Now, if the board is asking you, you have to give the answer with clarity and also with honest conviction that yes, this is why I want to do this. I want to go in civil services because this is one service where I see it can enhance my overall, yes, I can go ahead and do different types of jobs with respect to the diversification which is there in civil services. So ultimately, it's depends on one's passion or one's choice.
So, sir, while I was preparing for this podcast, I read a very shocking information that India has 15 judges per million, according to India Justice Report.
Correct.
So, sir, quoting this report, will NJAC solve the problem of pendency of court cases in our system in India?
See, first of all, if we talk about the judicial appointments, since you're mentioning that. So, one which we should be very clear about judicial appointments, that it takes place at the lower level of lower judiciary, where candidates are appointed and then they are recruited in the lower judiciary, right? Where the maximum they retire either at the level of district court or as a district judge, or they reach high courts. And then there is higher judiciary, correct? So lower judiciary examination is either conducted by respective state civil service examination or by respective high courts of state or union territory. Now, when we come to higher judiciary, so this takes place also either through a higher judicial examination, which takes place at the respective state level, or one is directly appointed from the bar, means someone who is practicing, because that is also a constitutional requirement that they can become judge of a high court or supreme court in case they have certain years of practice. So this is one aspect. Now coming to NJAC, the role of NJAC, if we go through the constitutional provision which under Article 124A, the functions under 124A and 124B, the functions specifically is with respect to recommendation of appointment of judges of High Court and Supreme Court, as well as transfer of judges of High Court. So maximum, yes, it will streamline the appointment process. Secondly, there can be a continuity because they will have a better sense of understanding in terms of, let's say, vacancy in the High Courts or Supreme Court. So when we talk about NJAC, National Judicial Appointment Commission, so again, we have to also understand the aspect of National Judicial Appointment Commission from the fact that according to the constitutional provisions, it also, but if it becomes a reality tomorrow, because as of now, the Supreme Court has declared it ultra vires or unconstitutional because it violates the principle of separation of power.
Okay, sir.
Why? Because it has also the composition. As per the composition, it includes members of it includes, yes, members of the Union Law Minister and two eminent persons to be nominated by a panel comprising the Prime Minister, the Chief Justice of India, and the Leader of Opposition. So you see, there are three people, as in Chief Justice of India, two judges of Supreme Court, and then three people from the side of the executive. So there might be an element of favor from one side, either there or this. This is what the court have also highlighted, that it violates in that sense Article 50, which talks about violation of separation of power. So talking about NJAC, as of now, it has been declared unconstitutional. But if again tomorrow certain structural changes are made, and on those aspects, if judiciary says that it's fine, then definitely we can have an NJAC, which will ultimately streamline the appointment.
Sir, district courts का तो problem फिर भी solve नहीं होगा इससे? District
courts, see, when we talk about district courts, so as I've told you, district courts may the appointment is done either at the state by the State Public Service Commission or by respective state high courts, and that depends कि their examination की frequency क्या है, whether the examinations are delayed, whether it is done on time, how much is the capacity, at what level, how many districts are there. So there are a lot of things which is dependent on that. And then also there are people who are practicing, let's say in the high courts, so they can also be appointed as judges of high court. Those people practicing in high court or Supreme Court, they can be appointed directly as judge of high court or Supreme Court according to the Constitution of India. So ultimately, if you talk about pendency, yes, India has population itself is so huge, and then there are always also cases. But another point to be noted is that in most of these cases, one party which is party to the dispute is the government itself. And there was also a Niti Aayog report which suggested that government should also introspect that areas where they are party to the dispute, that they should try to solve. Let's say there is interdepartmental dispute let's say this department versus that department. At least that can be sorted out through their, let's say, mediation or conciliation or alternate dispute resolution mechanism. So that is something which the government should definitely look into.
Okay, sir. And I also read that in America, there are 150 judges per million and we have 15. So what we can learn from them and how American judiciary system is different from ours?
See, first of all, their population is very less. Well, if we compare their population and ours, comparatively, it's very different. The scale at which the comparison we are doing, that itself drops drastically for America. Plus, they have a different legal system. Their constitution came into being in 1776. So they have, you can in that sense say civilizationally, they have been accustomed to a type of due process. They have their Bill of Rights, which they protect very guardedly. The Supreme Court of United States of America protects the Bill of Rights. So they have their own different type of judicial setup. And since they are a presidential form of government, right, they follow strict separation of power. So in that sense as well, the structurization is very different. And when we talk about the judicial setup, in India, we have a unitary judiciary. This is what we study. But there, the judiciary is both at the federal level as well as at the, yeah, absolutely.
Okay, sir. Sir, I was going through the transcripts also. So I have brought some questions from there also.
Sure.
So, sir, do you think that gender discrimination exists in legal profession and how it can be addressed?
See, when we talk about gender discrimination as such, whether it exists or not in the legal system, it will depend on how much percentage of women is there at different levels. As we talked about the district level, we talked about the state level, high court level or the Supreme Court. I was also going through some reports, India Justice Report, right? So it highlights that the percentage of women in the district courts is approximately, I think, 38 to 39%, which is fair enough, like not bad. So in that sense, we can definitely say, yes, there has been empowerment from women perspective. Now, why this is important? This is important because it sensitizes people. Let's say there are women in the judicial setup or the judicial in the courts. So obviously the infrastructure would cater to their demands. There would be women toilets. Now this very small yet important issue has been even highlighted by Chief Justice of India, former Chief Justice of India, particularly Justice Chandrachud, gave a lot of emphasis on improving the facilities for women, not only women judges, but also women lawyers. And if we look at our society as such, and let's say when our parents know that there are facilities for women are secure in workplaces, because we also have a law.
Exactly, sir.
The prevention of sexual harassment at workplace, thanks to Vishakha judgment. So all these gives a lot of confidence even to parents that yes, their daughter can pursue legal profession. And this is what the Chief Justice has been highlighting, that even women should take up law as a career, right? And they are taking it. So yes, the situation is definitely improving right from the bottom till the top. Because even if we look at the final, you can say, there is an advocates on record exam. So now women are clearing that more. So it means there are more women advocates on record. Advocates, yes, in the Supreme Court itself. So that also gives a lot of confidence that yes, see, as far as discrimination goes, that depends. But are women encouraged to become part of the legal profession? Definitely yes. So even Supreme Court have started these facilities, like women can carry their children. They can be there for some time, like,
in the creche facility.
Yes, something like that, yes. But these encouragement should come from the top to the bottom. And if, let's say, if the judges of Supreme Court, particularly the Chief Justice of India, highlights this aspect, then definitely this is taken up below the order at the High Court level and also at the lower courts.
Sir, if we talk about the new criminal laws, then many provisions have been taken from the older version.
I'll say this in a different way. We have been moving in terms of time. Now we have different technology. Do you think law needs to address those technological concerns?
Yes, sir. For example, AI.
For example, AI. For example, do you think AI needs to be regulated?
Yes,
its misuse needs to be regulated. Yes. Deep fakes are concerns, particularly for women, right? Don't you think it violates their privacy? And it's also an offense which should be punished. This is what the new law is. Okay. So the new law has various components, if you can say, that why we need such a new criminal law. First of all, the whole structure changes, whole perception changes, because when law or criminal law was drafted by the Britishers, particularly Lord Macaulay, so then British was governing India. And what were we? What were the people of India at that time? We were their subjects, not citizens. So according to them, we were the subjects, and accordingly they made law for us. And hence provisions like sedition were given a priority as compared to provisions like, let's say, murder or offenses against women such as rape. Now, what this law has done, first of all, obviously, that's what our Honorable Prime Minister has said, that to remove the colonial hangover, this is what he has suggested. So this is the perfect example of that. There were certain references also of, let's say, crown, or let's say queen, or let's say other sovereign nations. All those references have been removed. And this idea of Indianization of criminal jurisprudence or criminal justice is also reflected here. Second, structurization has changed. So under the previous Indian Penal Code, the offenses related to women were scattered across different, let's say, chapters. So now offenses against women and children has been provided under one roof, under one chapter. Okay. Similarly, other offenses like offenses against human body or offenses against property, all of that has been provided under a chapter, and these have been given preferences as compared to, let's say, offenses against state. So offenses against state, where earlier where the word sedition was there, now the word sedition is there.
Okay, sir. Yeah. So this is something I read very new. So what is soft law under international law?
See, when we talk about soft law are those laws which are, although not legally binding, yet they have a profound effect. For example, the best example of a soft law is Sustainable Development Goals, SDG goals. Now, soft law is generally associated with international environment law. Now, the whole movement of international environment law started with 1972 Stockholm Conference. And after that, 1992 Rio Conference took place. And in between, various international treaties were signed. Now, some of them were legally binding, some of them were not legally binding. So, those international conventions which are not legally binding are referred as soft law, particularly used under international environment.
So, sir, how these laws are incorporated in our system?
When we talk about international law being incorporated as part of our system, so here students should know two aspects. I'm sure they already know, that is monism and dualism. So there are a set of countries which follow this principle of monism, which means if international law, let's say they have ratified or approved certain international treaty, that itself becomes part of their legal system. So for example, America, some of the international treaty, they become part of their system, and it is also provided under Article 6 of their US Constitution. But when we talk about Indian Constitution or Indian system, we follow a concept known as dualism, which means, yes, we ratify an international law, but it does not mean that just by ratification it becomes part of our legal system. This process of ratification, which is done by representative of the executive, is done under Article 73. And then how does it become part of our law? Either we amend the existing law, whichever law is there, or we enact a new law. Now, why are we doing this? Because ratification means that we, on international forum, we are providing or we are ensuring this commitment that yes, we will follow all the provisions of this international law. For example, when India ratified WTO, GATT, then it also became party to TRIPS, that is trade-related intellectual property rights. And then accordingly, we had to make changes in different intellectual property right laws, such as Copyright Act, Patents Act. In fact, we enacted a new Trademarks Act, and then whatever protection is available under TRIPS, we have to enact a separate law for that. So that's how international law becomes part of our law.
Our system. Okay,
Yeah.
sir. Sir, recently the Trump's tariff policy were in controversy, that he is imposing such tariff policy. So, sir, was he violating the international trade law?
Now, this is one question which can definitely be asked by the students, that did Donald Trump, the President of the United States, violate any aspect of international trade law? Straight away answer is no. And this is covered under Article 21 of GATT, General Agreements on Tariff and Trade. Now, Article 21 says that a country can take such a measure if there are concerns on their vital security interest. Many countries have taken refuge of this particular provision. Now, Donald Trump has not only, when we talk about from the perspective of international law, so definitely Article 21 needs to be answered directly. But yes, Donald Trump has also used their domestic laws, their national laws, to support this tariff or reciprocal tariff measures. For example, International Emergency Economic Powers Act. For example, their Trades Act, Trade Expansion Act, particularly Section 301, 238, etc. So the point is that are these national national legislations under which Trump has taken these measures, are they violative of their own constitutional laws? And a case is also registered in their US Supreme Court. So I was reading an article which said that even if, let's say, US Supreme Court said that whatever decisions Donald Trump took, it was, let's say it is violative of, or it is ultra-vires or unconstitutional or invalid. Yet, Trump can take the refuge of Article 21 of GATT. I'll give you a very recent example of 2019 case. This case pertains to a conflict between Russia and Ukraine. And the conflict was actually more of an economic nature. So what Russia did on certain part of Ukraine, so Ukraine had to conduct certain trade. But considering their geography and their territory, Ukraine had to cross over the Russian territory to enter into their own territory. Russia did not allow that trade, or did not allow the Ukrainian trade to take place. So they filed a case in WTO. WTO on this front said that, see, whether you are taking an action actually in the national interest or in the interest of your security, that has to be seen. That has to be understood from the perspective that whether actually some security threat exists or not. So whether the decisions actually threaten the United States security interest, that is to be seen. But the grounds which Donald Trump has highlighted are two: that it is imposing those tariffs on those countries with which there is a trade imbalance. That is, there is the difference between import and export. So that becomes, in a way, you can say under international law, sort of a justified ground. And second, definitely national interest or national security interest. Again, it becomes very debatable and subjective in terms of opinion. But is there any protection available in international law? Yes, definitely Article 21 of General Agreements on Tariff and Trade. So if this if this question is actually asked, then this is something which student can definitely highlight.
Sir, whatever answers you are giving, they are they're comprised of articles, they are comprised of very legal terms and everything. So sir, does the board expect a law student especially that answer should be such comprising of such all the articles and everything?
There are two sides to it, right? First of all, it gives them a clarity that you have an understanding, in-depth understanding. Now, why I'm saying this? Because if we go through the notification about personality test, so this is what it says, and that based on your academic interest, which can also be, let's say, your area of graduation or your area of optional. So this is one part of academic part, right? And there also you have to have in-depth knowledge. You have to have that clarity of thought and a balanced view. So these articles actually don't give them a lot of scope, to follow up with something, let's say, where you give certain answers according to them. Let's say it's certain on certain extreme. Let's say if a student says ki Trump is wrong under international law, they can counter it with saying ki nahi, but there is a provision under General Agreements on Tariff and Trade. So rather than allowing them to counter you back, it's better to use these provisions. First of all, it gives you that protection. It gives the board an understanding that yes, you are very much aware about the legal developments, very well read, well thought, and your answers also appear balanced. Because this is one of the prime requirement for the board. Because see, what are they looking for? They're not looking for your answers. Honestly, they're not looking for what articles you quote or what provisions you give or what case laws you give as part of your answer. They're looking how you answer, with what manner you answer, with what poise you answer, and whether your answer reflects that suitability of public service. let's say, suppose someone's second choice is Indian Foreign Service or their first choice is Indian Foreign Service. Definitely, this question can be asked from a law graduate that do you think international law will help you there? So you have to again prepare an answer for that. That definitely yes, after understanding various aspects of international law, going through, international treaties, customary international law, different aspects of international law, it gives you a lot of clarity about that subject. You have gone through a lot of case laws, you have studied international, let's say international law of the sea, you have studied aviation laws, you have studied laws on anti-hijacking, all of that. So it widens your perspective. It broadens your understanding. And this is what they're actually looking for, suitability for public service.
So this is the last question which I'm going to ask. Sure. It's very current in news. So the question is, what do you mean by safe harbor principle? And has the 2025 intermediary rules diluted this protection? So sir, explain this please.
I'll explain this by giving an illustration. Suppose I made some reel. Yes, I posted it on Instagram. Okay. So in this case, Instagram becomes the intermediary.
Okay, sir.
Are me and Instagram related? Absolutely not. But I'm using the platform of Instagram as a medium to upload my reels or videos or whatever, or YouTube, right? Or any other social media platform. Now, let's say if someone or me post something which is illegal, which is, which is not allowed under the law, which is obscene. Of late, there are a lot of reels using deep fakes.
For example, Akshay Kumar recently highlighted this issue.
Yes. So the question is that intermediary liable now? If someone let's say someone puts certain messages on Twitter or X currently, is X liable? So earlier, prior to 2025 rules, what the situation was that generally these intermediaries were given certain protection from third parties. So we become the third party, whoever is posting any, let's say, video or reels on the intermediary platform. Now, what was this protection? Because this was created by us or such people, third party. So intermediary was not, you can say, liable till the time court or the government issued a prohibitory order to take those reels or videos down or to block them. Blocking means so that people could not see them any further. Simple, right? Now, if we look at the 2025 rules, it says that actually it incorporates the element of artificial intelligence, which you asked earlier, right? So it says if any person is making these reels or videos, and if they're using the component of artificial intelligence, then they have to highlight it as a part of, let's say, for example, we have to highlight it as part of the description, which we upload it on the internet or on the social media platform. And I made a video, for example, and I mentioned it that yes, I have used artificial intelligence. So the word used under law is synthetic. Okay. Whether it is like completely man-made or use of synthetic aspect, that is artificial. That is artificial intelligence. Okay. Now what happens? Suppose I made a reel. I mentioned it that it uses artificial intelligence. I put it on YouTube or on Instagram or any other social media platform. Now it becomes their responsibility to check whether I have posted something which, let's say, is not illegal, not an offense, which can be punished under any of the laws of the country. So the onus or the burden or the obligation falls upon these intermediaries. Now there is a kind of intermediary under the law, and the law under which these intermediary rules have been published is the Information Technology Act, and the provision which pertains to safe harbor mechanism, safe harbor protection is Section 79 of the Information Technology Act. So now this 2025 rules basically in a way has diluted it because the onus now shifts on these intermediaries, particularly the significant social media intermediaries, which means those intermediaries who have a registered user of 50 lakhs or more. Instagram, YouTube, Facebook, etc. It also says that they have to develop a tool through which they have to develop, let's say, an AI tool or any software tool through which they have to detect this. So now the government will assume that if someone has put, let's say, an offensive reel or a video, the onus shifts to the intermediaries. So that is what is being talked about, and it may be, you can say, may prove burdensome for such intermediaries, obviously, because they have to develop such kind of tools. So this is what changes has been done. And this change through the intermediary rules has been done by amending the previous rules, that is the 2021 rules, right? So one question which can be asked from, let's say, law student is that, don't you think too much of subordinate legislation is being used to, make changes under the law? So for that, they have to be prepared that as long as it does not violate the basic principles laid down in the INRI Delhi Laws Act, then it is fine.
Okay, sir. Sir, the last message you would like to give to the law students as well as all the aspirants who are appearing for the interview?
See, I'll try to give a very comprehensive message to everyone, particularly law students. If you are a law graduate or if you have taken law as your optional subject, see, the board is looking for someone who is suitable for public service. So this is what they will try to check your personality. How will they check your personality? By normal conversation, right? It will not be a cross-examination. It will be a normal conversation. So in that conversation, try to be firm, try to be poised, and try to give a very balanced opinion. And express your opinion very freely and frankly. And in case, let's say, they ask you any provision of, let's say, constitutional law or international law, and suppose you're not aware, just simply say, I'm sorry, sir, I'm not aware of this. I'll definitely look into it. So rather than giving an, ambiguous explanation or an explanation, which does not have any, does not make any sense, is of no use, because the board members are much more experienced people, and they should be respected for that, first of all. And when you are answering certain issues or whatever you are being asked, answer in a very poised manner. So this is one suggestion I would definitely give. And second, see, it's possible that question can be asked from a very generic perspective from your DAF or from a legal perspective. And it's also possible that from a common issue, such as, let's say, what we discussed today regarding tariff measures issued by Donald Trump. Now, there could be a legal aspect to it. There could be an aspect of geopolitics or international relations. How does it affect not only India's relations with America, but also, let's say, India's relation with Russia? Because just few days back, the Russian president was in India. And also, let's say, India's relation with China. Third aspect is obviously economic aspect. How does it impact India from an economic point of view? So it's possible that one aspect or one issue can have multiple dimensions. So make sure whatever you are hearing in news or whatever you are going through the newspapers, try to understand all those dimensions, and particularly the legal ones, because it's possible that a legal dimension can be asked from you, particularly from a law graduate. So this is what I would like to tell the student.
Thank you. Thank you so much, sir, for your precious time. And I hope, aspirants, you found this conversation helpful, useful, and you took a lot of insights from this conversation. And for the time being, signing off. All the very best, aspirants, for your interview. Thank you.